Power of attorney. This is one of the less understood pieces of the puzzle. And frankly, I think almost everybody should have a power of attorney. I get it if you're like, there's nobody I trust that much, Anthony. I'm not married. I don't have kids. Like, I don't want to just give it away to somebody. And okay, fair. You know your life better than I do. But I think almost everybody should have a power of attorney. And let me tell you what a power of attorney is. And I think it'll become clear why it's important. So, power of attorney, if you hear just regular power of attorney, they have authority, once implemented, over your financial and legal matters only. Okay? Now that usually surprises a few people because they're like, wait, I thought I was doing power of attorney so that they could make medical decisions for me. That is different. That's called medical power of attorney, and it only gives them the ability to do medical decisions, not legal and financial ones. Now, of course, you can have someone be both medical and regular power of attorney, so they could have the full scope. But know what you're signing up for, right? In Minnesota, and a lot of the stuff I'm going to talk about today is relevant to Minnesota and very likely relevant to most states out there. I'll throw in a little bit of Wisconsin knowledge, but if you're in a different state or you're wondering about a different jurisdiction, we should talk about that because I'm off the cuff most familiar with Minnesota, and then Wisconsin is a close second. So if you're talking about, well, how does this work in Idaho? Well, okay, let me look into that a little bit more just to make sure it works the same way. So disclaimer, but back to the power of attorney. In Minnesota, you can Google short form power of attorney on Google. The first link that comes up should be the Secretary of State's office. I believe it's the Secretary of State's office. It'll be a Minnesota state government website. You can just download the form and you can fill it out yourself. It has to be notarized when you sign it, and the person you're empowering, or people, because it can be multiple people, also have to sign it. They don't have to get their signature notarized, just yours. But then you can do it and it's done. And unless you have a very complicated situation, that's probably what's going to work for you. That's what I have, for example. My wife and I are power of attorney for each other at this point. And that is a good strategy, by the way, to do spouses for each other. Because, for example, any retirement account any one of you has can only be titled in one person's name. You can't own it jointly. It's just because of the way the tax code works. Which means that if you call me up and say, hey, my spouse is a client of yours and he's unfortunately going through some stuff and we actually need to take some money out, can you just send us this amount of money? If I don't hear from the literal account over, even though you're married and I know you, that's not enough authorization. You're going to have to show me that you're power of attorney or get the actual account owner on the line. And that's a security thing. Like, that's not my choice. It's how the industry works. So getting that in place ahead of time, obviously, is crucial. Now you